With 19 members present, a quorum is present. So today we are just going to be doing one bill. I'd like to recognize Representative Cassidy to present House Floor Amendment Number 1 to Senate Bill 25.
Thank you, Madam Chair, and members of the committee. I am grateful for the opportunity to discuss this critically important issue. The Reproductive Health Act repeals the Illinois abortion law of 1975 that is mostly enjoined based on federal decrees and injunctions. With the new Trump appointees to the Supreme Court and the federal courts across the country, we simply can't continue to rely on bad law protected by federal injunctions. The RHA codifies our existing practice and this is critical, treats abortion care just like any other health care, because it is, while responding to coordinated, pointed, and strategic attacks on reproductive rights across the country. This means using the same medical standards, known as the accepted standards of clinical practice, for abortion care that we use for other medical care, including other kinds of reproductive care. And I want to note here that several colleagues came to me and to the advocates with concerns and suggestions, and I want to thank them for their collaboration and assistance in strengthening this proposal. We've seen the opposition intentionally misconstrue the intent and the actual language of bills that seek to provide affirmative protections to reproductive health. They spread misinformation and fear that distract from the reality that bills like this one have been reviewed by medical associations who don't have a pro-choice agenda, all the while passing laws that are not based on medical standards or clinical practice with the sole intent of outlawing abortion. Make no mistake, it doesn't end here. Since Roe was decided in 1973, our opponents have fought to impede access to care, and these efforts have the greatest impact on the most vulnerable populations. Women of color and the poor, traditionally segments of the population without the ability to work around barriers of cost, time, and distance. I believe that Illinois is better than that, and the RHA can help us show that while affording critical protections for vulnerable populations. I'm joined by Colleen Connell of the ACLU and Dr. Tabitha Wells, and I would like, do we need to adopt the amendment, actually?
No, that comes later,
Okay.
after discussion.
Thank you.
So I'd like to read the witness slips. There are actually quite a few. There are 365 proponents, and and then there are 1,537 opponents for this legislation. There are 2 who would like to provide testimony as proponents, and there are about 14 that would like to provide testimony as opponents. Because there's so much interest in this issue, I would like to give everyone an opportunity to speak, but I would like us all to be reasonable about how long you speak, preferably 2 minutes. Okay, can you do that? Okay. Pardon? Oh, would you like me to read all the witness slips? Call Justin. Or you call him. We're going to find out. We're going to find out if we absolutely have to. But I'll start. Amanda Kemme, oral testimony. Angie Crary. These are all opponents. Ben Kemme, oral testimony. Brian Suler, oral testimony. Dale Brackenhoff, oral testimony. Dale Henkel, oral testimony. Greg Zavitz, oral testimony. Jody Pride, oral. Deborah Brentenlinger, oral testimony. Christopher Langford, Diocese of Joliet, oral testimony. Kevin, oral. Leslie Lewis, oral. Mary Hairwalt, oral. Maurice McCutcheon, oral. Corey Respondick, oral. Marlene Kretkowski, oral. Mary Crawford, oral. Brian Mills, oral. Michael Groth, oral. Michael Kearney, oral. Nancy Brockenhoff, oral. Sharon Brannigan, oral. Rob Zunbehalen, oral. Raquel Mitchell, oral testimony. Ralph Rivera from the Illinois Right to Life Action, oral testimony. Zach Wickman, oral. Zachary Adam Bailey provided written testimony. Randall Fucht, the rest are appearance only. Randall Hargate, Randall Hartman, Ray Gaddy, Rhea Waldo, Rebecca Collick, Rebecca McBroom. Don't have to. Okay. Because of the late hour and the quite the large number of witness slips, I will not be reading the rest of them. They will be available in the record. Okay. Representative Harris?
Madam Chair, I'd like to make a motion to waive the reading of the witness slips and to include them in the official record of the hearing.
Do we need to? All those in favor vote aye. All opposed say nay. Aye.
Aye.
In the opinion of the chair, the ayes have it, and they will. Clerk, please take the roll. It's a motion? No, the motion passes. We're moving on. Okay. Please, sponsor, please proceed. But we'll hear from the proponents first.
Good evening. My name is Colleen Connell. I'm a lawyer and the executive director of the ACLU of Illinois. I've been practicing law for almost 40 years and have appeared at federal and state courts at all levels, including arguing before the Supreme Court of the United States. Before becoming executive director of the ACLU of Illinois, I led the ACLU's Reproductive Rights Project. In that role, I represented the doctors and women who successfully litigated Illinois laws restricting abortion and other reproductive health care. In short, I won most of the injunctions that blocked these laws from going into effect, as referenced by Representative Cassidy. The Reproductive Health Care Act would literally clean up the Illinois compiled statutes by repealing these laws, some nearly 50 years old, that are blocked from enforcement by ACLU injunctions. The RHA would treat reproductive health care like all other health care, rather than subject physicians to criminal penalties for exercising their medical judgment to care for their patients. The RHA would essentially codify what is the current state of medical practice and care in Illinois. Specifically, and I'm just going to hit some of the high points here, the Reproductive Health Act would repeal the Illinois abortion law of 1975, which imposes restrictions on birth control, abortion, and certain types of reproductive health technology. It would also repeal the so-called Illinois Partial Birth Abortion Act, which is enjoined permanently and which has been replaced by a federal law that regulates care in this area. It would repeal the Abortion Refusal Act, which is redundant with protections of the Illinois Healthcare Right of Conscience Act, as well as certain other federal laws. It causes confusion and is unnecessary. It repeals a provision that allows a husband to try to get an injunction to prevent his wife from getting an abortion, a provision that is unconstitutional and contrary to Illinois law, which specifically upholds the right of a married pregnant woman to consent or refuse to consent to her own medical care. The RHA also repeals numerous provisions of the Ambulatory Surgical Treatment Center Act, the Hospital Licensing Act, and the Medical Practice Act that are enjoined by virtue of the Ragsdale Decree and that are inconsistent with Illinois regulations that have been promulgated in response to this decree. It also does various other amendments that clean up Illinois law. Importantly, the Reproductive Health Act also affirmatively recognizes as fundamental the right of every person to make reproductive health decisions, from birth control to abortion to maternity care, all essential parts of care, especially given the current context in which states have enacted numerous laws in 2019 that essentially ban all abortions. Passing House Bill 40 was an essential first step. House Bill 40 repealed only a single provision of the Illinois abortion law of 1975 that expressly provided that if Roe is overruled, then the former policy of the state to prohibit abortions unless necessary for the preservation of the life of the woman shall be reinstated. In effect, since it amended the Illinois abortion law, House Bill 40 left in place numerous other restrictive abortion laws that I summarized earlier that have been blocked from enforcement by ACLU injunctions.
Could you please wrap up? We just have so many speakers.
Yeah,
we'd like
absolutely,
to.
yes. In short, as Representative Cassidy said, it is an urgent time. There are numerous cases in the pipeline to the Supreme Court that could essentially overrule or seriously erode the protections that Roe provides for essential reproductive health care. Thank you very much.
Thank you. Tabitha Wells?
Good afternoon, Madam Chair and members of the committee. I am Dr. Tabitha Wells. I am a physician specializing in family medicine. As a family medicine physician, I see patients of all ages and provide a wide range of care, including prenatal care, delivery, contraception, abortion, pediatrics, preventative care, chronic disease management, geriatrics, and other types of care. I am here today to urge you to vote for the Reproductive Health Act and to bring a voice to the thousands of Illinois patients and their healthcare professionals who are depending on you to protect their fundamental right to reproductive health care. As a physician, I am duty-bound to practice informed consent with every one of my patients. In order for there to be true informed consent, a patient must be able to weigh all of their options and have the information necessary to make the best decision for themselves. When a patient does not have access to all of their options for health care, then they absolutely cannot truly make that fully informed decision that is best for them. That is why I support the Reproductive Health Act. The RHA establishes the fundamental right to a full range of reproductive health care, including the right to use or refuse to use birth control, the right to continue a pregnancy, the right to parent or not to parent, the right to adopt, and the right to have an abortion. Each of these options must be available and accessible so that every patient can make their own reproductive health care decisions in consultation with their healthcare provider. I'm aware that so much of the debate around the RHA has been around abortion. It is unfortunate that there has been so much misinformation spread about this legislation and about abortion in general. First, contrary to what you may have heard from opponents of this bill, abortion is one of the safest types of medical procedures. 40 years of experience and numerous studies have shown that the vast majority of abortions can be performed safely in office and clinic settings. 2/3 of abortions occur at 8 weeks of pregnancy or earlier. 89% happen in the first 12 weeks. Complications from having a first trimester abortion procedure are rare. Major complications occur at a rate of less than 0.5%. Abortion has not always been so safe. Prior to Roe v. Wade decision in 1973, abortion was illegal in all or most U.S. states, and many women died or had serious medical problems as a result of unsafe abortions. Once abortion became legal, women had access to trained healthcare professionals, which dramatically improved safety. According to a 2018 study by the National Academies of Sciences, Engineering, and Medicine, abortions are safe, Complications are rare, and women who have abortions have no long-term consequences on their physical or mental health. In addition, the study found that laws and regulations that treat abortion differently than other forms of healthcare do not improve patients' health, but rather create barriers to safe and effective care. Currently, in Illinois, abortions can be and are safely provided by physicians who provide in-clinic and medication abortion, and also by advanced practice nurses and physician assistants who can prescribe medication abortion. These healthcare professionals receive specialized training in order to provide quality care to their patients. The RHA will ensure that patients will continue to have access to safe abortion provided by healthcare professionals according to accepted standards of care consistent with the scope of his or her practice. Secondly, abortion is one of the most common medical procedures in the United States. Women who have abortions come from all walks of life and all backgrounds. They are all ages, all races, all ethnicities. They are rich, middle class, they are poor. Some are religious, some are not. They are single, married, divorced, widowed. Most have children, some do not. Some have suffered sexual assault, sexual abuse, or domestic violence. Some have major health issues. Women who have
Doctor, can you wrap your comments up? I'm just trying to be fair and giving everybody a chance to speak.
The most devastating thing I've ever done as a physician is telling expecting parents, patients of mine, that the pregnancy that took them over 1 year to conceive had a condition that was incompatible with life. These patients had to make one of the most heart-wrenching decisions they ever had to make in their life, one that they thought they never would have to make. They were pro-life before they had to have an abortion to end the suffering of their child. These diagnoses are usually not found until 21 to 22 weeks gestation at the earliest. Some patients decide to proceed with these pregnancies, others let nature take its course. For some, these pregnancies are too risky to continue, for others too traumatic. All patients deserve to have options available to them so that they can receive the best care. The Reproductive Health Act ensures these.
Thank you.
Thank you.
Thank you very much. So we have two people who are representing organizations from the opponents. I'd like them to speak first. Christopher Langford from the Diocese of Joliet, and Ralph Rivera from Illinois Right to Life Action are two who are representing organizations. Let's start with those two. Again, 2 minutes, please.
Zach Wickman with the Catholic Conference will be the other person speaking.
You file a witness slip?
Read it.
Okay.
Oh, okay. Okay, excuse me. So Ralph Rivera with Illinois Right to Life Action. We only had a little over an hour to look at this 126-page bill and make sure, but there are some key things that we want to point out. Let me talk about one. The current law says that the U.S. Supreme Court said that the state could prescribe or prohibit abortions after viability, except to protect the life and health of the mother, and that's the current law. But this changes the definition of viability, and that's a concern because, as you know, viability with medical technology and so forth gets lower and lower. Back in 1975, viability might have been at 28 weeks. Now it's going down to 20. But this has changed in the definition. So the definition for the Illinois abortion law of 1975, in part, the key part says that there's a medical judgment that there is a reasonable likelihood of sustained survival of the fetus outside the womb with or without artificial support. But that's changed in this amendment. The amendment says for fetal viability, and the key part is that there is a significant likelihood of a fetus sustained survival outside the uterus without the application of extraordinary medical measures. So that means that before you can prohibit abortion, the doctor has to determine viability. And that's changing that from maybe 20 weeks to maybe 26, 28 weeks. And that's different than what we have right now. And so that now gets into more late-term abortions because our prescription of after viability for life and health, before that kicks in, you have to have a viable situation. And they're making that later, not sooner. And that's of great concern as we talk about late-term abortions. So I wanted to point out that key factor. Also, the law, this bill removes a second physician to help that second patient or that viable child if that child was viable and able to sustain survival outside the womb. That has been removed from this. So that's a crucial part as we're talking about late-term abortions and when the state can help that child at viability.
Madam Chair, members of the committee, thank you for the opportunity to testify. My name is Zach Wickman. I'm the Director of Government Relations for the Catholic Conference of Illinois. I'll start by noting that I have not read the entire 128 pages or 26 pages of this amendment. It just was filed not too long ago, but I am very familiar with the original bill and the amendments there. So if I do get something wrong, I apologize in advance, but I think I understand the amendment as it's presented. It's not just a cleanup bill. That's the way the proponents continue to portray this bill, but it's not just that. There are many new provisions in this bill that don't exist in law today. For instance, the mandate on private insurance to cover abortion. It is true that the Healthcare Right of Conscience Act provides insurance companies who have in their governing documents conscience objections to abortion to not cover it. However, corporate insurance don't have these types of provisions in their governing documents. And while the Diocese of Chicago or any of our dioceses are self-funded and therefore have in their governing documents these objections and don't have to cover it, there are many small churches and nonprofits who are too small to have self-funded insurance plans and are therefore cut off from this option and therefore will have to turn to the private insurance market where there will be no exceptions. Another provision that's new, this language here. A fertilized egg, embryo, or fetus does not have independent rights under the laws of this state. The state shall not deny, restrict, interfere with, or discriminate against an individual's exercise of the fundamental rights set forth in this act. That's from the bill. This is new language. It strips completely any rights of the state or any interest of the state to protect the rights of the unborn. And you'll notice that the proponents have dropped another bill that they've introduced, which is the repeal of the Parental Notice of Abortion Act. But if in this bill, if it were to become law, it says the state cannot deny, restrict, or interfere with, how can the Parental Notice of Abortion Act survive legal challenge? There will be a conflict in the law that judges will have to decide. And so for this reason and many others, the fact that, obviously we believe abortion is a tragedy for the unborn baby, for the mother, for the father, for society as a whole, something that we should not be promoting, something that we should not legalize in such a callous manner, in such a broad manner. We are opposed to this bill, and I ask you to vote no. Thank you.
Okay. I'm not sure if these individuals who filed these witness slips are here, but I'm going to read their name, and if they would like to come up and make some brief comments. Amanda Kemme, Angie Crary, Ben Kemme, Brian Suler, Dale Brackenhoff, Dale Henkel, Deborah Bretlinger, Christopher, we already went, Eric Thayer, Greg Zavitz, Jody Pride, Linda, Kevin, Corey Respondick, Marlene Kritkowski, Mary Heerwald, Maurice McCutcheon, Michael Kearney, Nancy Brackenhoff, Rob Zumba-Halen, Sharon Brannigan, Raquel Mitchell, Brenda Reinhardt, Mary Crawford, Brian Mills, Michael Goth, Leslie Lewis, Zach Wickman, Zachary, and that's it. Okay. Are there any questions from the members? Representative Demmer.
Thank you, Madam Chair. I'd like to renew one of the objections and the points that I made on the House floor just before we got organized in this committee tonight. We all know we sit here after dark on Sunday night before Memorial Day. This legislation, this bill, was originally filed in February, was assigned to a committee in February, and then sent to a subcommittee. No hearings were ever scheduled on it, and the bill was triggered by the deadline that said that if bill remained in committee, it'd be re-referred to the Rules Committee. As you watch this process, many people originally expressed their opposition to this bill, or perhaps their support for this bill. But as they saw, there were no committees scheduled, there were no hearings scheduled, there were no votes scheduled, and the bill was subject to the legislative rules that all bills here are subject to. However, for some reason, this bill today at 6:08 p.m. resurrected. This bill came back. People who had been watching this, tracking the progress of it, people who cared deeply about it on either side, didn't know the bill was going to come back today. At 6:08, that posting was made for a meeting that, not exaggerating here, was scheduled to begin at 7:08, exactly 1 hour after the posting, the absolute minimum amount of time that could be offered for a bill to be considered by a committee of this House. I'd also point out that this bill, which is not an appropriations bill, was sent to an appropriations committee of the House. This bill does not make any appropriations for the state. It's a substantive bill, but it was sent to this committee. Nevertheless, as I said on the House floor, the Illinois Constitution specifically protects the rights of citizens of Illinois to be heard and represented in the legislature. In Article 4, Section 7, it specifically requires that meetings of committees of each House shall give reasonable public notice, including a statement of subjects to be considered. No one from my district could have made it here to testify on this bill with 1 hour's notice. I imagine that's true of many of our districts. Could any of your constituents make it here in 1 hour to offer testimony on this bill? The chair just read out several names of people who wanted to offer oral testimony. Perhaps they're on their way. Perhaps they're still driving here and are not being given a chance to be heard because of where they live, being more than an hour away from the Capitol, or because they weren't sitting by their computer on a Sunday night of Memorial Day weekend wondering if a bill, which had been assigned to subcommittee 3 months ago, was going to resurface tonight. I would also point out that as members sat down, we were each given a packet of letters from proponents, from supporters of the bill. They all, coincidentally, mentioned specifically Senate Bill 25, which until 6:08 p.m. was not publicly disclosed as the bill for which this amendment would be filed on. They also say that this is appearing before the Appropriations Human Services Committee, which again, until 6:08 p.m. tonight, was not publicly known that this was going to be the committee to which this bill was assigned. There's a packet of letters here. So obviously, proponents of this legislation were given adequate public notice. But I'd point out the Constitution does not say proponents of a piece of legislation shall be given adequate notice. It says that everyone shall be given adequate public notice, supporters or opponents. The Constitution does not just protect the interests of someone who seeks to pass a piece of legislation, it protects the interests of all people in the state of Illinois. This committee is clearly not being conducted with adequate public notice. Even in the short period of time that was available, 1,500 people have filled out witness slips because they were in a position to be able to receive this urgent alert. As I said on the floor, and as I renew here, as the minority spokesperson on this committee, I strongly object to the procedure under which this bill is being considered. This should be given the intense public interest in this on both sides, we should be given the fair opportunity to hear from citizens who support and oppose this bill. Today, that public notice and that opportunity to participate was given only to those who support the bill. That's simply not the way the Constitution set out for this state to operate. Thank you.
Representative Morgan?
Thank you, Madam Chair. Just a quick response to the process, and there was already a response on the floor for those of you who did not hear from the other side of the aisle. On this piece of legislation, I've received quite a number of comments, and from my district, which is a pro-choice district in the northern suburbs of Chicago, I heard responses both for and against this legislation for the last 5 months. So the idea that this has not been vetted, the idea that we haven't heard or thought about this, and even in the last week, there have been a tremendous number of news reports about the intention of this body to take up this legislation. So it's all about context, and I think it's important that we talk about the specific process that we've undertaken here, and the fact, and my friend from the other side of the aisle acknowledged 1,500 comments were already received in this, albeit last hour or two, about this legislation. So I do think there's been quite a bit of vetting on all levels of this legislation. So that's my response to the process. But I want to talk about the substance. Again, I did receive quite a few comments and letters and calls in my district about this legislation, people that were supportive and people that were opposed. I seriously appreciate and consider those that are in opposition to this legislation. I think that there are a number of people from all walks of life who take this issue as a moral, a religious, and a truly personal issue, and I respect that, and I think it's important that we all acknowledge that. I also think this legislation has become quite a Rorschach test. I think people can look at this legislation and have it say anything and everything that they want. That's just simply not the case. It's not the facts that are in front of us. We have very specific legislation that this sponsor brought to our committee and to this chamber, and that's what we're here to consider. When I considered my own personal perspective on this, I thought a lot about the individuals in my life, in particular the women, not just my wife, who I spoke to about this legislation quite a number of times, but also my young 2-year-old daughter, and about the position that I would be taking to impose my will on her decisions and her choices and her safety in the event that 20, 30 years from now, she's faced with a decision to protect the safety of her own body. And whether I as a legislator and we as a government would make the decision for her about what she can and cannot do with her body. And I reject the premise. I reject that choice. So I'm proud to stand in support of this legislation. I thank the sponsor for the work that she has put into this, including the changes that she has made to reflect some of the concerns that others have brought to her. So I urge a yes on this bill. Thank you.
Representative Bailey?
Thank you very much. Ms. Cassidy, I'm just curious. In 2017, the Illinois Department of Public Health posted there were 39,832 abortions performed in Illinois. How many of those were medically necessary to protect the body of the woman who was getting the abortion?
I don't have that information.
Well, I mean, I keep hearing distraction from reality. I keep hearing misinformation. I just heard Representative Morgan talk about protecting your own body. 39,832 abortions in 2017, and we don't know how many of them were medically necessary?
I don't have that information available to me right now. I will tell you that my abortion was medically necessary. It saved my life. It preserved my fertility. It allowed for the creation of my family, my children, who are my world.
I see where you guys made some changes. It's kind of interesting. We've changed fertilization. We've changed that to implantation of an embryo. We've changed individual. We've changed the word woman to individual. I mean, who else can get pregnant besides a woman? Why did we change that?
Anyone with a uterus and ovaries can become pregnant.
So someone else other than a woman can get pregnant.
Anyone with a uterus and ovaries can become pregnant.
Does anyone other than a woman have a uterus?
Anyone with a uterus and ovaries can become pregnant.
Thank you. Misinformation, distraction from reality. When does it end? So I find it interesting that the one thing that didn't change was the word unborn child. Can you give me your definition since you wrote this up? What is the
Where are
definition
you
of
in
a
the bill?
child? Pardon?
Where are you in the bill?
720 ILCS 5-9-2.1.
What page of the bill are you looking at?
Well, I'm looking at a, see what the page is. 1 second, I'll give you the page.
Can you read the rest of the citation? 720 ILCS.
5/9-2.1, 3.2, and 12.3.
So you're referencing several sections of the criminal code which we do not amend.
Well, you changed, in those you changed implantation of an embryo. You switched that from fertilization. Then you changed the word woman to individual. I'm just curious why you didn't change unborn child. And I'm asking you, what does unborn child mean? Because, I mean, what does that mean to you, that word? Because obviously words mean something here. So what does unborn child mean?
In the case of this law, it refers to an implanted embryo, which it reflects current medical standards.
Is unborn, so child means life. Would you agree with that?
It means an implanted embryo.
Okay, well, I think obviously then to your comment, science tells us then that means life. So would you expound a little bit on, I see that doctors and hospitals that can opt out of this process will not be, what does that look like? What does that mean?
This also does not impact the Healthcare Right of Conscience Act, which allows for that opt-out.
In the 1975 section, the penalty, the sentence for intentional homicide of an unborn child shall be the same as for first-degree murder. Is that changed any?
I don't believe so, no. I'm going to ask Colleen Connell to join me for some of these.
I'm curious on some of these situations where do we draw the line at that a woman could have a C-section instead of an abortion with I keep hearing the woman's own body is at harm and is at stake. So if we're got a situation where the woman is ready to give birth or the fetus is viable.
I think you just answered your question.
So where is the
You
line at
referenced
between having
viable.
a
That
C-section?
is medical. That is as defined in the Act, a medical decision. I'm sure the doctor would be happy to discuss that.
Whenever a fetus is viable, we do everything we can to save both the mother and the fetus. We would not perform an abortion if the mother's life is at risk when we're able to save both the mother and the fetus.
Okay, tell me that one more time, please. Because if a woman comes in for, if a woman is,
If the woman's life is in danger, we do everything we can to save both the woman and the fetus.
so how many of these 39,832 abortions, how do we know that someone just didn't have an abortion instead of a C-section
That
to
data
save
is
a
not
life?
collected.
Pardon?
The only collected data when abortions are performed is the number performed. The reason for an abortion is not collected or reported.
All right, well, thank you very much. I urge a no vote on this disgusting bill.
Representative Williams?
There are a number of reasons that I support this bill, but in the interest of time, I'll just go through a few of them, actually 9 of them. Alabama, Georgia, Louisiana, Missouri, Ohio, Utah, Arkansas, Kentucky, Mississippi, And that's just a start. I'd urge a yes vote.
Representative Bourne?
Thank you, Madam Chairman. It's a great follow-up from the last speaker. To be clear, question for the sponsor. In the case, we've heard this many times, in the case that Roe v. Wade were overturned tomorrow, abortion in all instances until viability, and abortion post-viability for life and health of the mother is still legal in Illinois if this is passed or not, correct?
All of those rights are at risk once Roe falls. All of the enjoined acts in our statutes would be subject to litigation and potential reviving.
I'm not talking about enjoined acts, I'm talking about legal abortion, right? Trigger language already repealed under House Bill 40.
There's
would
criminal
remain.
penalties for physicians performing those abortions in our statutes.
Abortion
Legal or
is
not,
still
there's
legal,
penalties there
that are currently enjoined.
and could be very easily lifted.
I highly doubt that. I know that we have very different thoughts on where this bill needs to go, but in the interest of a committee, I think it's very important that we dig into the language of the bill and get to the intention of it, because I have some questions about getting into the weeds. So I will not be worried about the interest of time. I have quite a few questions. The first one, what is your definition of a fundamental right?
Sorry, I wanted to check if that was actually just a phrase or a legal phrase, and it actually is, which refers to that person's ability to make decisions about things like religion and healthcare and self-determination.
Right, so I mean, other fundamental rights in law are equality, freedom. They're subject to strict scrutiny in judicial cases. So we are adding abortion to the list of fundamental rights like equality and freedom in our laws. Is that correct?
I believe that we are enforcing a woman's right to self-determination.
What does it mean if we change the current law so that an unborn baby has no independent rights? I think this gets to a question that Representative Bailey was asking. No independent rights, does that trump the fact that if an unborn baby were killed, homicide, unintentionally, they have no independent rights under the law?
Representative Cassidy has asked that I take this question. The Reproductive Health Act does not strip the state of its ability to take action if there's been a situation as specified in the intentional homicide, the involuntary manslaughter, the voluntary manslaughter provisions that allow the state to prosecute someone if that person attacks a pregnant woman and harms not only the pregnant woman, but also the fetus that she is carrying. Likewise, the Reproductive Health Act leaves in place Illinois' Wrongful Death Act, which allows usually the expectant parents to bring a wrongful death action in the case that a third party, by which I mean not the pregnant woman, tortfeasor, attacks or causes some kind of negligent action which injures the pregnant woman and the unborn and the fetus. What is really essential to note is that current Illinois law, namely these criminal penalties and the Wrongful Death Act, are very explicit in saying that they do not apply in the context of health care, including abortion. And so the Reproductive Health Act leaves these provisions in place. In addition, the Reproductive Health Act is consistent with Illinois decisional law, including the Supreme Court of Illinois' decision in 1988 of Stallman versus Youngquist, in which the Supreme Court declined to allow a child to sue her mother for acts that happened when the woman was pregnant with this young woman and that caused injury in utero to this child. And the Illinois Supreme Court wisely recognized that if it were to allow a child to sue his or her mother for acts that caused harm in utero, that the Supreme Court would be creating a legally untenable situation in which the pregnant woman and the fetus were legal adversaries from the moment of conception until the moment of birth. And that, quite frankly, said the Supreme Court, would be just an untenable situation in which the pregnant woman, really, would essentially not be able to make, really any decisions during her pregnancy. And so the Reproductive Health Act leaves in place very important protections in the Wrongful Death Act and in the
It leaves
criminal law.
protections in there, I know, but it also says they have no independent rights. Is there any other case in our law where someone who has no rights could have a criminal penalty for harming them? I mean, how do you recognize in statute, one, that an unborn baby can be killed and there can be criminal penalties for that, yet they have no independent rights? Does that not seem like
Actually, it's very
difficult to reconcile to?
No, it's actually very consistent with what has been the progress of the common law, quite frankly, for decades. And basically what, the courts have recognized is the loss expectancy interest of the pregnant woman and the harm that was really, initially inflicted on the pregnant woman. So I think that this again is, the Reproductive Health Act leaves these provisions intact.
Okay. Could you expand on, this is one of the new provisions of the bill, could you expand on the life and health of the mother? This seems much more expansive than the current definition, so I have some specific questions. One, it gives a list. Health of the patient, all factors that are relevant to the patient's health and well-being, including, but not limited to, physical, emotional, psychological, and familial health and age. When you say but not limited to, what else are you opening this up to? What are you envisioning this includes?
Representative, that language comes directly from the Supreme Court's 1973 decision in Doe versus Bolton, in which the court defined health to include but not be limited to the factors that you laid out. This definition of health, this
So
broad
if it's been in
definition
place
of
since
health,
73, what else has it not been limited to, other than these factors?
it basically recognizes that the decision about health can involve a multitude of factors that have to be based on essentially the case before the doctor at that point in time. And this is very consistent with
Yes,
medical
but I'm asking
standard.
for specifics, right? You're saying this language has been in place since 1973. Certainly, there must be cases where these factors were not included and there was something that was not limited to, right? A specific case where a woman went in, it was the health of the mother, not limited to these specific factors. Can you give me any other factor that has been included?
No, I think
outside?
that I cannot. I cannot. I think that it's a very broad definition of health.
Very broad, extremely
and it was
broad.
appropriately broad because I think as again, the Illinois courts have recognized in a couple of cases, including In re Baby Boy Doe and In re Baby Boy Brown, that a pregnant woman's health has to be the priority of the physician during pregnancy. I mean, that is the standard of care. That's the standard of care that we all expect when we go in and seek medical care. We want the doctor to look at us as an individual patient and take into consideration the health.
Not just
risks that we
health, this
face.
definition is well-being. That seems overly broad to me, right? You can imagine a number of cases where a doctor, let's say someone goes in to have an abortion, the doctor is determining, is your health and well-being at risk? That seems to go way beyond a medical scope to me. Is that what you've seen in practice? It could be financial well-being, it can be...
I don't ask my patient why they're having an abortion. It doesn't matter.
Even if the baby is viable, you have to.
In Illinois, I don't perform abortions after viability, so no, I don't ask.
But it's legal to receive an abortion
Not after viability.
post-viability if the life and health of the mother is at risk.
In Illinois, I don't perform abortions post-viability, number one. When they are done post-viability, it's truly for the health, like a patient who's crashing. I mean, we take that very seriously.
A
If it is
patient who's crashing how?
like
Health and
dying,
well-being.
it's truly done when someone is dying. That is when it happens, post-viability.
We are talking about instances where you have to ask the patient, right? We are talking
That
about
doesn't happen
post-viability.
post-viability. Post-viability abortions happen when the patient is dying. They have cancer. The pregnancy is going to kill them if they don't get treatment for their cancer.
Under current
Representative-
statute, I'm asking in
Representative
practice.
Byrne, there are other people who would like to speak as well, and please
No,
don't interrupt
this is a
the...
very important bill. I'm trying to get to the point so that we are not stalling further.
Keep asking the same point, and they keep answering you, and you don't like their answers.
They're
So
talking
it-
under current statute. In practice, with this new definition of health of the patient, this is talking about post-viability abortions.
And I'm telling you the answer. Doctors are not going to be performing abortions post-viability unless the patient is dying.
But that's not what this legislation says.
And
This
I'm giving you the
legislation-
answer of what doctors are going to do. Doctors are not going to be performing abortions just willy-nilly.
Then let
It
me
is
ask
going
you-
to be because their patient is dying.
Then let me ask you in practice, if you are given this definition,
My practice
Of
in
health
medicine
of
is not going to
patient.
change based on legislation. It never has, it never will.
I would hope that your practice changes based on legislation and what's allowed and what's not allowed. But if you were given this definition, as an abortion provider who is looking at a post-viability abortion, and your scrutiny has to be on the health of the patient, and it says, a patient's health and well-being, including, but not limited to, physical, emotional, psychological, and familial health and age, you cannot tell me that that only includes patients who are in the act of dying.
I don't know how to answer your question any differently.
Okay. I think we've established that this is much broader than just a patient who is dying. Health and well-being, including but not limited to physical, emotional, psychological, and familial health and age. That was my next question. What does familial health mean? Is that outside of the mother and her baby? Is that other children, spouse? What does familial health mean?
Representative, this standard, and again, I want to go back and say, it's been upheld by the Supreme Court in 1973. It was upheld again a few years later in the Colati versus Franklin case, 1979. Basically says that we are going to trust physicians to make the decisions based on the individual case before them to best protect their patient's health. That is what we want physicians to do. That is what physicians do all the time. This standard in terms of allowing abortions after viability only if necessary to protect the health or life of the pregnant woman is almost identical to the standard that is in current Illinois law, Section 5.1 of the Illinois abortion law, which says after viability, no abortion can be performed unless it's necessary to save the health or life of the pregnant woman.
I
Okay, do you
understand
have
what it
further
currently says.
questions? Do you have further questions?
What does I have a lot more questions,
keep-
which I said
well,
at the beginning. What is familial health? I'm
Well, you-
asking, what is familial health? Does that just include the mother and her
We're not gonna be
unborn
here all
child?
night.
Or does it extend to other family members?
I do not know what the Supreme Court had in mind when they
Okay.
used that term.
Okay, well, I think it's important before we put it on our statute, we know what it means. Moving on
Representative
to,
Byrne, you have one more question, and then we're moving on to the next person.
I would contend that I have
You may,
30 more questions on the text of the bill. We are talking about over 100 pages of a bill that we saw less than 3 hours ago. We have questions about what this means being put in statute. Committee work is where we get into the meat of the bill. It's where we get our questions answered.
the language of this bill has been out for many, many months.
Actually,
this is
the
a small
definition-
amendment to it.
the
There have been a
definition we were
number of
just-
changes.
The
Not very
definition we were
many.
just talking about came
30
out
of
in
those
this
questions,
amendment.
probably 28 of those questions were on the basis of the bill that has been out there for months.
That is on the new definition of the life and health of the mother, which was not included in the previous bill. Another change, this is my next question, another
It's
change.
not going to be 30, I'm telling you that right now. So why don't you pick your top 3?
I'll ask compound questions then. I've got a question about reporting. We heard earlier that currently we don't know why these abortions were necessary. We don't have any statistics about what was essential for the life and health of the mother, what was a question that we often have on the exemptions of rape and incest, what percentage of abortions really, what percentage of abortions would include those exemptions. I've seen FOIA exemptions in this bill. What will the public be able to know about abortions performed in Illinois if this law were passed?
To the first half of your question, 91% of abortions were performed before the 13th week of pregnancy. So we're talking about much, much earlier. In terms of the reporting, it's not a question that we ask. We don't ask why. It's just not, frankly, why I had my abortion is none of your business.
I'm not asking to expand the reporting requirements. I just saw FOIA exemptions in this bill.
There are FOIA exemptions in many Illinois laws to protect very important privacy rights of people. There are FOIA exemptions to protect law enforcement sources. There are FOIA exemptions to protect state and national security. FOIA exemptions are very common in public health reporting statutes, and what the RHA does is essentially assign to the Illinois Department of Public Health, as is the case in other public health reporting, the obligation to determine what kind of reporting is essential for the Department of Public Health to collect important public health data.
So I still haven't gotten a direct answer. If we FOIA how many abortions
That's
were
2.
performed in Illinois.
Is that your second question now?
No, I'm trying to get the answer to my original question with what information will be reported. Is it the number? Is it the age of the women who went in to get an abortion? We're able to get that information now. Will we be able to get that information after this law is passed?
Yes, because that information is reported annually by the Department of Public Health. It is not something that is reported only because of FOIA.
Okay. Colleen, try to keep your answers short as well.
As I was reading through the bill on the floor this afternoon, what oversight or standards are going to be there for abortion facilities by taking abortion procedures out of licensed ambulatory surgical treatment centers?
Those provisions have not been applicable to abortion providers since the 1985 decision in Ragsdale. The Reproductive Health Act will treat abortion providers just like other healthcare providers who are subject to appropriate public health and licensing requirements.
Your last question.
With the chair's indulgence, I have two more that I have deemed my most important. This one, I think, should be short. Currently in statute, we prohibit sex-selective abortions. The injunction that was placed on that was only for criminal liability for physicians. Yet in this bill, you are repealing the prohibition of sex-selective abortions. Can you explain why?
That whole injunction is repealed, but frankly, that would fall under the medical standards of care that that will apply to all of that decision-making between a patient and a physician.
Okay, my last one. Can you explain, this is, again, the brand new language that we just saw today. This is not something that we have digested over months. This is brand new. Fetal viability, the definition. In a professional judgment of the attending physician, if there is significant likelihood of a fetus's sustained survival outside the uterus without the application of extraordinary medical measures. Could you give me a definition of extraordinary medical measures?
For a fetus, it would depend. Most fetuses early on are going to be intubated. For a fetus, I would not consider that extraordinary. Most are going to be intubated. Depending on where you're at, they might be airlifted to a NICU. That may or may not be considered extraordinary depending on where you're at. If you're 8 hours away, probably extraordinary. If you're in Decatur, coming to Springfield, probably not extraordinary. For some babies, once they're born, you could be talking about multiple surgeries. Antibiotics, not extraordinary, but multiple surgeries, pretty extraordinary. We do some other treatments that are pretty simple, IVs, medications, not very extraordinary, but some of the treatments that we do are pretty extraordinary and painful to keep it simple.
Okay. This is the most concerning piece that I've seen in the bill, and I'll explain it as briefly as possible, but I think it's very important that people understand that this bill contends that it is protecting viable fetuses from an abortion. Yet, a baby is not considered viable if they require extraordinary medical measures, which we just heard could be geographically determinate. So if you live in the most rural part of Illinois, and you know that when that baby is born, they might need to be airlifted to a NICU, which is not next to them at a hospital near them, they could be never determined viable while they are not yet born.
That wouldn't be the only thing. It's all of the factors combined. Because we might not be able to save a baby who's 8 hours away. The baby might not survive 8 hours away from a NICU.
Exactly. So you just said, if you know that this baby, you're seeing them on the ultrasound, they're developing, and then at some point you realize this baby, this pregnancy is high risk, this baby is going to need to go to a NICU. Under this definition, that baby could be determined to never be viable until they are born. When we look at, you were talking about surgeries being extraordinary medical measures. We're looking at, here's the March of Dimes, reasons that babies go to the NICU or need surgery. Very simple procedures if they have a heart abnormality. Procedures where they could weigh too much or be growth restricted and they have to go to the NICU. You can see these on an ultrasound.
None
You
of
go
those
in,
would be considered extraordinary measures.
a heart surgery? You just said surgery would be
Did
extraordinary
I say
medical
all
measures.
surgeries? I said certain surgeries.
Would closing a hole in a baby's heart be extraordinary medical measures?
Depends on what it is. Some of them, no. Some of them are quite easy.
We are talking about 10 to 15% of babies born in the United States every year require a short stint in the NICU. Under this bill, it is reasonable to believe that that means 10 to 15% of babies before they are born would be considered never
Absolutely
viable.
not. A NICU stay would not mean extraordinary measures. Just being in the NICU is not an extraordinary measure. That's not what I
You said if a
said.
baby had to be flown to the NICU, that could be considered an extraordinary measure. I'm going off of your
I
words.
didn't say just because they had to be flown to the NICU.
Yeah, flying was the key word there. Thank you, Representative.
Flying is the key word.
Representative,
This bill is a gross expansion of post-viability abortions, regardless of how you slice it, regardless of how you define extraordinary medical measures. You've defined it a few different ways. This bill requires much more debate. This bill requires much more digging into. I have probably 20 other questions that I thought would be important to dig into the legislative intent. Some of these provisions are very vague. Some of the things that we are repealing, I think, are being repealed unintentionally and will have negative consequences. And the fact that we are debating this bill on a Sunday night where the majority of my questions came from the two definitions that we just saw today, less than 3 hours ago, and we're pushing this through is unconscionable. I'm very disappointed with the process.
Representative McComey.
Actually, I want to respond to one piece. I'm sorry. I don't accept the characterization of this as expanding post-viability abortion. It keeps existing law in place with respect to viability. It reinforces the standards of medical care, the thing that keeps a doctor licensed. It's not, I fully reject your characterization.
Representative McComey.
Thank you. First, I just want to respond to the process. Of course, we all have heard from our districts. The entire Capitol was shut down on what people thought about on this topic. The thing that is unfair about the shortness of time is that people want to get on the record. That's the part of the process that's missing today. Not that we haven't heard from folks. I'm fortunate in my district. The pro-choice people in my district don't agree with late term. They don't agree that taxpayers should pay for it, and they wouldn't have abortions themselves, which I always find interesting oftentimes. One of the questions I had with the new definitions, when you're talking about the fetal viability, before, from my understanding, to be viable, it was reasonable, was in the definition, and now that is drastically being changed. And when you're looking at determining the fetal viability and the health of the patient, when you go to get an abortion, the doctor, well, the nurse, well, it doesn't have to be a nurse now, it could just be a health professional, to determine the health of the patient. Is that the same person now who is going to be doing that?
What is your question?
Is it the person to determine the fetal viability and the health of the patient? Is that going to be the same person who's going to be performing the abortion?
The only professionals who can perform procedural abortions in the state of Illinois under current law and under this law will be physicians. That is a physician. And it is about the standards of medical care that they operate under in order to remain licensed.
So will this physician be that person will be the same person to determine the fetal viability and the health of the patient will be the same person. They'll be the same person will determine that.
It depends on the clinic setup. Fetal viability is usually determined by gestational age ultrasound. The physician is not always the person doing the ultrasound. Some offices have a certified ultrasonographer who's determining that. Sometimes it is the physician doing the ultrasound.
I'm pretty sure that no doctor is going to perform a surgery without having all of the information. So yes, the physician is making this determination.
Is there a requirement for the ultrasound on the baby prior to aborting it?
What do you mean by that?
No, we do not have an ultrasound requirement. What we require is the accepted standards of medical care in which the physician can only make the decision with all available information. I will tell you, I had several ultrasounds before my abortion.
Well, and that's one of the things that kind of really does disturb me. I don't know your story. It sounds horrible, just from the statement you made earlier when you were speaking. And I'm certainly sorry that you had to go through that from what I've heard.
I'm not sorry. I'm deeply grateful it was that option was available to me.
No, I'm saying that the term abortion, because I personally don't feel when a woman's health, I don't consider that term abortion. When I think about an abortion, I think about you choosing and I believe life begins at a conception. I grew up with a mother who believed in pro-choice, and especially as I got older, not being able to have children especially, I got more and more and more believing that. So I've gotten stronger in my view on that, but I just feel a little bit differently. And so I don't feel when a woman, the life of a mother is, I don't think that should be termed as an abortion per se. Maybe that view is different for others, and I don't know, like I said, I don't know your story.
I
so.
choose not to judge people when I don't know their whole lives.
And
That's
I'm not
my
judging. I'm not
position on
judging
it.
you at all. My mother had an abortion, and I'm not judging her either, at all.
But I don't sort them into categories in the way you just did. That's all.
Okay, I'll move on. Another thing that was being said oftentimes throughout is that abortion is the most common choice. And I just want to say that I feel that that's sad.
I didn't hear anybody say that abortion is the most common choice.
I'm sorry, I don't remember your name. You had mentioned...
Dr. Wells, but
Dr. Wells?
common medical procedure is what I said.
It's just a common medical procedure is all she said, not the most common choice.
Okay. Well, I heard common choice, so maybe I was hearing what I wanted to hear, that you had stated that. And I was just wanted to say, my niece, 18-year-old niece, had just recently had a baby boy, or baby girl, Braylee, and we talked about, even as me being pro-life, talked about her choices, and I was very glad that she had somebody that she could talk to with her mother and her father and her aunts and uncles, and have somebody that was open to having to talk to, that she could know that there's more to this than just abortions and whether or not she was able to care for this little girl or not. And I just really feel that this is something that is really going to be expanding things. And I just feel like everything is so fast and moving, and when kids are younger, they feel like this is their only choice, and I think sometimes we make it too easy, and I just really hope that we all are very aware that that life is life, and it's our point to be protecting it in all cases. And I just feel like in the cases of, we have somebody in our house that is pregnant and under this bill, because she chooses to, could abort it. And I think that is not right. And I'm sorry, I just don't think that's right. And I urge a no vote.
I would add, the Reproductive Health Act is not just about abortion. It protects maternity care and fertility treatment, and our colleague's ability to make decisions about her birth plan and how she wants to deliver. It protects the full scope of reproductive health care.
Representative Moeller.
Thank you, Madam Chairwoman. Thank you, Representative Cassidy and Dr. Wells and our legal staff who are here to provide testimony. I appreciate you being here for this important issue. I want to challenge some of the notion that this bill is expanding or somehow changing the standard of care or the access that we're talking about in terms of reproductive health care, which we've heard a little bit tonight. And I respect those who have a fundamental objection to abortion. People of good conscience can disagree on this issue. But I think we need to be careful and accurately characterize what this bill actually does. It maintains the status quo of access to reproductive health care in our state in the event that Roe is overturned. And as my colleague, Representative Williams, alluded to in her testimony, we are at a very precipitous moment in our history where we are seeing so many states directly challenge Roe in a way that we've never seen before. So I think we can all agree that the women's access to this kind of care is directly threatened in our country, and that this bill protects what currently exists in our state. So with that understanding, and am I correct in making that statement? If and when Roe is struck down and this bill fails to pass, I think reasonable people would agree that victims of rape or incest who become pregnant and are opting to terminate should have access to that care. There are a lot of states, even in states that have banned or implemented these heartbeat standards, have given exceptions to rape and incest. Would women in those situations be protected if Roe were to be struck down and we were unable to pass this bill and these cases were challenged? Would doctors feel that they were legally within their rights to help in these types of situations?
I think that if Roe is overruled or substantially eroded, the injunctions that the ACLU has secured that prevent the enforcement of many parts of the Illinois Abortion Act, as well as the other regulatory procedures I outlined, those injunctions would be at risk. And I think that the risk of abortion access would be pretty broad, and we could face a situation like happened in Texas when the so-called trap laws, the injunctions that we got in the Ragsdale case, essentially resulted in the closing of many, many clinics in Texas, and so access for all women was severely restricted. And I think that, to reinforce a point that Representative Cassidy made earlier, the women who suffer the most when restrictions go into place are often the most vulnerable. They may be low income, they may be women with serious health conditions, they may be victims or survivors of rape or incest or intimate partner violence, who may not have the ability to seek abortion care early in pregnancy when it's perhaps most accessible, even under an eroded standard. Even though there is at present no law on the books, even enjoined, that is so draconian as the laws that Representative Williams ticked off, I think those access issues could become a very serious problem.
So there would be uncertainty in the law, and
there would be.
And as you mentioned, the standards for clinics and potentially even doctors, performing health care in hospitals or established physicians' offices there would be a chilling effect,
There
to
would be
say
a
the
chilling
least.
effect, yes.
You also mentioned, or it's my understanding, that this legislation also affects access to birth control and contraceptives. And if, again, if the legal framework were to change, access to those types of, to contraceptives would also be impacted. Can you talk a little bit about that?
Yes, several provisions of the Illinois Abortion Law of 1975, as amended several times, define certain forms of contraception not as contraception, but as abortifacients or abortions. Those methods of birth control would be at risk if Roe is overruled, and those injunctions would be lifted.
Okay, thank you. So essentially what we're arguing tonight is not necessarily, this is not about expanding or creating a new level or category of health care that previously was not available to women in the state. This is protecting existing access to health care that we currently have and is threatened under potential
That is correct,
litigation. Okay. Thank you very much.
Representative Windhorst.
Thank you, Madam Chair. If this bill were to become law, what would be the consequence to a doctor who committed an abortion or performed an abortion on a post-viable fetus if it were not for the life or health of the mother?
That physician, in the unlikely situation that you outlined, because just again to reinforce what Dr. Wells said, after a fetus is viable, the doctor really tries to move toward delivery in an effort to save the life of both the woman and the fetus. But in the event that you have a physician who is acting contrary to those medical standards, that physician would be subject to the same professional licensure and professional liability regulation that all physicians in Illinois are subject to when they practice medicine in a way that is not consistent with accepted medical standards. And so again, the Reproductive Health Care or the Reproductive Health Act treats abortion, contraception, reproductive care like other health care, and submits doctors to those licensure and professional regulations.
So the consequences would all be within the medical community?
No, actually the consequences of the professional liability, like for example, malpractice, is not just within the medical community. It's the courts of law of the state of Illinois.
So there could be a suit for malpractice?
I think there could be.
Who could bring that suit?
That I don't know. I'd have to think about that a little bit.
Well, it seems like it'd be a pretty basic question. We're talking about consequences for violating
Right.
a law.
Right, but
If you have a
I'm-
law in place, what the consequences are.
But
So
I'm saying I'd have to think about that. Whether it would be, the pregnant woman who would. I'd have to think about
the
that.
pregnant woman would be ostensibly
There's no other
going to the
pregnant, right,
physician, so
yeah.
she would be unlikely to sue. Would anybody else have standing to sue?
Again, that's, oftentimes patients sue their doctors for malpractice, even though the patients obviously went to the doctor for medical care.
But there would be no criminal penalty
There
for,
would be no criminal
for
penalties. That's
performing
correct.
an abortion on a post-viable fetus, correct?
Just like there is no criminal penalty now for, performing other kinds of medical care that does not comport with medical standards.
But those often don't involve taking a life.
Even in situations in which the physician's actions result in the death, for example, of whether it's a pregnant woman or whether it's a man, that malpractice does not usually result in criminal prosecution, even though a person might have died.
I know, Dr. Wells, you said you would not perform an abortion on a post-viable fetus unless it was for the serious physical health of the mother. Is that correct? Now, Representative Cassidy, this bill does go beyond that. I know Dr. Wells is speaking for herself, but she can't speak for the entire medical community. The definition of health is broader than just physical health of the mother. Would you agree with that?
Once again, doctors have to comply with the accepted standards of medical care. You're talking about a thing that doesn't exist. It's really that simple.
I'm just
When a
asking-
patient
I'm just asking
requires
about the
that
law.
level of care late in pregnancy, they are in a tragic circumstance
I agree.
requiring emergency care. We can spend all night talking about the mythical situation, or we can actually make good law in Illinois.
Okay, that's fine. So why don't we just define viability then as a serious physical health of the mother? For, not viability, but the exception for health. Why don't we define it that way?
Once again, accepted standards of medical care require a doctor to evaluate several factors, which is why we don't put a number in our statute, because my 20 weeks isn't someone else's 20 weeks.
Well, I'm not
We are
talking about
requiring
that.
doctors to use accepted standards of medical care.
If it's going to be for the physical health of the mother, why don't we define
We are
that?
requiring physicians to follow accepted standards of clinical practice.
What was the need for changing the definition of viability from the current law to this proposed bill?
As Colleen shared, this language has been Supreme Court language for decades.
Are you referring to viability or health?
So I think Representative Cassidy was referring to health, which again tracks Supreme Court law for almost 50 years. The definition of viability also closely tracks the existing definition. It's not word for word identical, but it closely tracks it.
Well, I'm sorry to interrupt because I know we're in interest of time, just why the change? Because the prior law, the current law, I should say, the current law fits within the definition as provided.
We were of the opinion that this language, as slightly revised, comports with accepted medical standards, and we did work with medical professionals in an effort to craft something that was comprehensible and that, again, comports with accepted medical standards.
At what point in Illinois law does an unborn child receive civil liberties?
I think that consistent with the Illinois Supreme Court's decision in Stallman versus Youngquist, as well as the common law, the law has recognized, as it really must, that during pregnancy, the pregnant woman's health needs to trump other factors. And it is, I think, quite, so I'm just going to stop there.
At what point, though, is the life of the unborn child protected under law?
I think I answered that earlier with respect to your colleagues' questions, and the fact of the matter is that the Reproductive Health Act leaves in place both the criminal laws regarding attacks which result in harm or death to the fetus, as well as the Illinois Wrongful Death Act. So those laws allow protection during pregnancy, as is articulated really, quite frankly, in both of those laws, except, of course, in the abortion context, which both of those laws carve out.
And at what point does the unborn child receive protection without the exception of abortion?
At the point of implantation, but the criminal. I'm sorry, I didn't understand your question then.
I'm saying, at what point is the unborn child protected from having his or her life ended through an abortion? What point does the unborn child receive protection under the law?
When they're born.
So I think the Reproductive Health Act basically, again, tracks current law that's been in place for almost 50 years, that a woman has a protected right to decide whether and when to become pregnant. She has a right to have an abortion prior to viability, and as the Reproductive Health Act, as amended by House Amendment 1, makes clear after viability, a woman can have an abortion only if needed to protect her life or health. And again, that is consistent with really, I think, what has been the state of medical care for much longer even than Roe versus Wade, which is that the woman's health has to trump and take priority in those situations. I think that, when you think about it in the context of, other medical care and other situations, neither you nor I could be forced to give a kidney or a lobe of liver to any of our children who are, my children are now both young adults. And the courts have recognized that really, each individual has the right to make their own health care decisions consistent with what is best for their own life and health. And I think that the reproductive health care, again, sort of protects the status quo and really reinforces the notion that women have this right and do not lose the right or forfeit the right to make decisions to protect their own life and health by virtue of their pregnancy. And again, the Illinois courts have recognized that, and they've recognized that in the context of refusing to order a pregnant woman to submit to a cesarean section or even blood transfusions, even when physicians have said that that medical care is needed to protect the health of the fetus. The courts have still protected, the Illinois courts have still protected the right of a pregnant woman to make her own medical decisions, even if those decisions have an adverse effect on the fetus. So again, to quote Representative Mueller, the Reproductive Health Act really does protect and codify the status quo of decisional law as well as what has been the few provisions of the statutes that remain in effect and not under injunction.
If
Representative, you have how many more? Is this your last question?
I think I have two more questions.
2 more questions? Okay.
That's all right.
Okay, 2 more. This one and one more.
Thank
And
you.
I hope they're unique.
If Senate Bill 25 were to become law, would there be any protections in Illinois law for unborn children who survive abortion and are born alive?
I think that again, reinforces the status quo. And if a pregnancy is terminated after viability, as Dr. Wells said, every effort is made to protect, try to protect the life of both the woman and the now born child.
Does the unborn child have legal protection, is what I'm asking.
I would be required to resuscitate the infant.
Yeah.
This law would remove the requirement of a second physician to attend to the child, isn't that correct?
I would attend the infant. I'm trained to do that.
I understand, and I'm not doubting your training. I'm just saying having a second physician to attend to the child. Why
We
is
don't
that?
require 2 physicians at cesarean births. We don't require 2 physicians at major surgeries. We don't get into the business of telling physicians much about how to do their jobs because, newsflash, we're not physicians, which is why the accepted standards of medical care are in place.
Yeah, when I do a vaginal delivery, there's not a second physician in the room for the baby. If the baby needs something, I attend to the baby and then go back and finish attending to the mother.
Well, the situation you've described where these abortions are performed post-viability is a pretty dire situation as I understood your description of it. Would you agree with that?
Yes, and if a baby after a vaginal delivery is in a similar situation, it's just as dire.
Yes, but you would not need another person to assist with dealing with both the child and the mother?
I would have a nurse in the room just like with a vaginal delivery.
So the nurse, not a doctor.
It's no different. An abortion is actually safer than a vaginal delivery.
And to be clear,
Oh,
when
an
I
abo-
had
an
my
abortion-
twins, there were multiple professionals in the room, not because Illinois law required it, but because accepted standards of medical care required it.
I just want to make sure I understood correctly, because I've seen some research that went the other way, and talking about a post-viability abortion is, you're saying, safer than a vaginal delivery?
Yes.
Representative Bryant?
Thank you, Madam Speaker. First, I know it is late, and so I just want to go back over a couple things that I think I heard, and then I know that there are other members that are listening tonight, so I want to recap a couple things and just some final thoughts. So can I just go back to the statement about when these decisions are made about the baby being viable and the mother's health, right? So the physician that's making the decision about the viability of the baby and the mother, it's the same physician making the decision on both?
Yes.
So,
Actually, I think the answer would really be maybe. It depends on the case.
so I guess my question is, often the decision's going to have to be made on whose health comes first. How does the one decision, I mean, because I'm just going back on my own children's birth. So I know that you have, for vaginal birth, you have the one doctor there for yourself, but you also have a pediatrician available that's going to come in and care for the baby, correct?
No.
That's not true.
The only time there's a pediatrician available is if you're expecting something to be wrong with the baby.
At all points of the delivery. I mean,
I only ever have a nurse in the room with me.
who does the APGAR check and all
The
of
nurse.
that? The nurse does.
The nurse or me.
Okay. But the physician is going to be making a decision on both the baby and the mother at the same time, one physician making the decision on both in the
Possibly.
case of an abortion.
Possibly.
Okay.
I mean, it would
And
depend on the
accepted
situation.
standards of medical care. If the case requires it, they get the support they need because physicians are trained to make these decisions. Legislators aren't.
So let me just back up then. So I just want to be sure that what we're saying, so presently, there is not the requirement of two physicians to be there in case of a viable birth. We're not changing that
I
with
don't know
this
the
piece
answer
of
to that.
legislation. Did I not hear someone say just a moment ago that we right
There
now
is
require-
nothing in law that talks about how a patient is attended and during a birth. What we have done is put in place, and has it been enjoined as well? Is two doctors at an abortion.
Yeah, I'm not talking about others. I'm talking about at an
Yeah,
abortion.
birth, no.
Presently, there are two doctors available for an abortion. This bill changes that.
No, the current Illinois law requires two physicians to be present in the case of a post-viability abortion, which again, I think we need to just underscore is extremely rare.
I mean, will you know in advance that there'll be
Pardon me?
you know in advance that there's going to be you know in advance that that baby's going to be born alive and be viable? How do you know to have that second physician there?
So you make
I'm trying to
that-
understand the process.
No,
I'm
no,
not trying
no.
to be
So, no, you would make that determination, again, based on medical standards, based on the facts of the case in front of you. And so, again, just to reinforce what Dr. Wells said, and now I'm going outside of the abortion context, but I'm going into the context of, okay, go ahead.
So currently, if this were to happen, I had a patient that this happened to. In this case, we wouldn't even call it an abortion. I had a patient that I was talking about earlier. They were diagnosed with a very severe syndrome that was not compatible with life. They were 26 weeks along by the time all the testing was done. We did an induction of delivery because the baby was not going to survive. The maternal fetal medicine doctors did all the diagnosing, amniocentesis, all of that. The second physician that was there was the NICU attendant. I delivered the baby at 26 weeks. The NICU was present. The baby was born alive. She lived for 3 minutes. The mother held the baby the entire time. No measures were taken. They did not want any measures taken because they knew their baby was not going to survive more than a couple minutes. That's how most post-viability births happen.
I understand that that's how maybe they most happen. I'm asking what is the requirement right now? Right now, for an abortion, is there a requirement that a second physician be present or available?
Only after viability.
Does this law change that second physician having to be present in the same circumstances?
This law repeals the criminal abortion law of 1975, including the
I'm
requirement.
a pretty simple
including the
person. Just a
requirement.
yes or
no, no, no.
I'm just a
no,
pretty
I
simple.
can't answer this yes or no. It repeals that provision of the Illinois abortion law that requires a second physician to be there in abortions after viability.
Okay, thank you. Again, I'm kind of a cut and dried kind of person, so I'm going to just kind of go back to the title of this being a Women's Reproductive Health Care Act. It's a beautiful title. I think that if we were actually here tonight to talk about women's reproductive health care, we would be discussing some of the other issues that were mentioned: maternity care, fertility care, birth control. I believe that this bill flies in the face of a woman at her most vulnerable time, generally scared, confused, perhaps mentally ill, perhaps developmentally disabled, seeking help from other people. And at a time when they're that vulnerable, we don't offer them the things that were just mentioned. We're offering them the ability to take the life of an innocent unborn child, one that someone else might want. Now, I do understand and appreciate that we could argue all night about whether a woman has a right to do with her body what she wants to do. I certainly will not argue that, because there's a few folks in here where we talk about, fighting for our rights or whatever. But I will argue all night that one person does not have the right to take the life of another human being. And I think it's evident with this piece of legislation that we're a little bit confused about when that person is a person, when we're still saying that we will keep in place laws when, if there's a baby that is wanted, then there's value to that baby's life, and someone can get a felony. If the baby's not wanted, then apparently they have no value at all.
There's no such test in the law.
I'm not talking about the law, Representative. I'm not talking about the law. I'm talking about basic human rights. If it's a felony to kill a child because it's wanted,
Again,
it's wrong to kill a child because
nobody's
it's
going to ask
unwanted.
if the baby was wanted or not.
I'm never going to argue that with you. I won't argue that with you. What I will argue with you is that this is a human life. I won't get into religion with you. You know where I am on this. But I will tell you that this is a human life that is fearfully and wonderfully made in the image of God. Period. I want to go over just a couple other things on here just to remind the other members that are listening here tonight, because there have been conversations that have been going on the sidelines, and I know in caucuses, so this is what I'm taking away from this tonight. This bill removes a second physician when there's viability, changes the definition of viability, no independent rights of the unborn child, questions regarding if this bill also applies to parental notification. Those are real and true questions tonight. And then to just go to this process once again. The people that I represent live a minimum of 3 hours from here. I found out about this bill being called tonight when I was unfortunately still about an hour from here because I've been kind of ill. There's no possible way that any of the people that I represent could have been here. When this was HB 2495, there were 20,000 individuals who put in witness slips to be heard. Today, Senate Bill 25 was hijacked in order to make sure that this was heard on a Sunday night, on a holiday weekend, at the 9th hour, in what I would really consider the secrecy. It's rushed. I would have liked to have heard the other questions that Representative Bourne had. I believe that Representative Windhorse had other questions. I believe that every single person's name should have been read tonight, whether they were in support or opposition. They should have had the right to do that when that was asked. This process, although long, has still been hijacked. I find you, Representative, even though you and I don't agree on some things, we've often agreed to disagree agreeably. I don't think that the way that this has been handled, it's a travesty for the high calling that we have and for the high position of this chamber and this House. I don't think it rises to the quality of legislator that either you are or the leadership of the House of Representatives, and I'm disappointed that it's been handled this way today. For those of you who are members who are listening, please listen to what's really been said tonight. This bill is not what it's being presented. It is not a Women's Reproductive Health Care Act. It is a bill to take the life of the innocent unborn. The end.
Thank you, Representative. Let me just state again for the record that the vast majority of the language in this bill has been available since early in session. This bill has been out there. This issue has been out there. It's a national issue. It has gotten press in all of our newspapers. There was a commentary just today on this issue again. This is not a new issue. This is not a new issue to the people of the United States. We've been arguing this issue for a very long time. And as you know, the process in Springfield can be varied, and bills come up, especially this last week. So it's not that unusual that we are hearing this bill now. The next speaker, Representative Gong Gershowitz.
Thank you, Madam Chair, Representative. I could say a lot tonight about why I support this bill, but for tonight, I really just want to clarify one thing. Under our constitutional framework in the United States, under federal and state law, there are really two sources of law, statutory and common law as developed by the courts. It's my understanding that the primary difference between the Reproductive Health Act as originally filed in February and this version is language with respect to abortions later in pregnancy post-viability. And I just have one question, and that is the intent of this version to codify common law standards developed under Roe versus Wade, not to expand them? Thank you.
Yes.
Thank you.
Representative Freese.
Thank you, Madam Chairman. Just a couple of questions. It was mentioned earlier, we were handed a number of letters, written testimony, and I want to just ask a couple questions that relevant to health of the patient. There's a statement in one of these written testimonies that says, years after seeking an abortion, women denied their wanted abortion were 4 times as likely to have their household income below the federal poverty level and 3 times as likely to be unemployed. So is fear of poverty, is that a factor relevant in determining the health of the patient?
I have not seen those letters, so I can't really speak to them.
Okay, let's just say that's not in a letter and I just made that up. Could you answer the question then? Is that a factor?
We're talking about accepted standards of medical practice.
Any comment to that? Would that be a factor in determining the health of the patient? That fear of poverty?
So, Representative, I just want to be, and I apologize for restating what has been said many times before. The health and life standard is a standard that is applicable after viability to determine whether the woman is actually going to be able to have an abortion at all. But as and that's a legal requirement at this point in the existing law, and the Reproductive Health Act would keep that. What that letter was really referencing was the fact that women denied abortions, and I'm assuming that that is really, sort of talking sort of globally and not, it's not limited to post-viability abortions, that their family economic status is affected by their inability to access the health care that they needed.
Okay, if I could follow up, another statement was women who are denied an abortion, let's see, how's this, experience significantly poor maternal bonding if they were denied abortion. So is that the fear of poor maternal bonding? Is that's you're going to fall into the same category as being a factor in the health of the patient, as was mentioned?
Again, accepted standards of medical practice.
Okay. I'm going to go a different dot, totally away from that, to still try to connect things. It was mentioned earlier in testimony that religious organizations that are perhaps too small to be self-insured and must go to the private market, are they going to be forced then to cover these procedures? Is there any relief for these organizations?
The Healthcare Right of Conscience Act would protect their rights.
Okay, and thank you for that. And then just for, again, getting back to process and procedure, if I don't want to know addresses or anything, but the two ladies that came, and I'm sorry I don't have your names. And I know it's on the record so I can find, but did you have to come in from out of town for the testimony tonight? And I mean, were you?
No.
Okay, you're from town? And you were from farther than an hour away?
I've spent most of the week here in Springfield, Representative. I'm from Chicago.
Okay. You spend the week here because, when were you made aware of this hearing, if I may ask?
The hearing tonight?
This hearing tonight.
The same time everybody else was, when I saw it posted on the board, the message board outside the House chambers, sir.
Well, I'm sorry. Yeah. So you just found, I mean, we found out at, what was it, 6:07 that we were going to meet at 7:07 or something like that. So you found out that at that same time?
Sir, as I said, I've spent much of the week in Springfield, and I'm very proud of the legislative staff of the ACLU of Illinois, who've also spent their Memorial Day weekend, like all of you, in the city of Springfield.
And then, but what was pointed out is we've received a lot of letters that happen to know, as was already previously pointed out, that that this particular committee was going to be hearing this. They knew that. That's a lot of work to get done and printed up in an hour. And I'm just wondering, too, if you knew about...
I am unaware of the source of the letters. I truly haven't seen them.
So the two of you are testifying, you're going to tell me that you didn't know that you would be here testifying at 6:07 tonight?
No, I'm on call, so I happen to be available.
Good. Thank you.
Sir, I just want to underscore a point that Chairwoman Gable made. The text of these bills and public debate of these bills has been going on since the bills were introduced in early February. And the letters that you referenced were, statements that people made and have now amended. That's one of the, I think the electronic age has a lot of wonderful things about it. This is one of them.
Yeah, okay. Well, I would just say that I think you both are very professional and presented great testimony. I appreciate you being here. However, I wish perhaps we might have known with a little bit more timing to have some rebuttal arguments. I'm certainly not a lawyer. I'm certainly not a doctor. I'm trying to understand this the best I can in order to make a judgment. So I'm glad you're bearing with me, and just wish we had a better process. Thank you.
Are there any other witnesses who would like to speak? Okay. Well, I appreciate you bringing this bill forward. I think that we are living in very dangerous times. I think our rights are being taken away or being threatened to be taken away almost every day. And this women's right to choose is one of them. I think that I appreciate that this bill will codify what the current law is. You know, I came up at a time before when abortion was illegal, and the thought of going back there is pretty terrifying. I mean, women were dying just to try to control their own reproduction. There was very scary times. So I really do appreciate this, and I want to give the sponsor an opportunity if you'd like to close.
I just ask for your aye vote and your support. I thank the committee for their indulgence. I thank my colleagues from the other side of the aisle for your heartfelt testimony. Obviously, we both feel passionately. We feel differently. So thank you.
There being no further debate, Representative Feigenholz moves to recommends that House Floor Amendment Number 1 to Senate Bill 25 be adopted. Clerk, please take the roll.
Gable?
Yes?
Harris? Demmer? Bailey? Feigenholz? Freeze? Gahn Gershwitz? Hernandez? Moeller? Morgan? Mussman? Villanueva? Willis? Windhorst? Bryant? McCombie? Bourne? Cassidy?
Yes.
Williams?
12 to 7. There being 12 votes in favor, 7 votes opposed, 0 voting present, House Floor Amendment 1 to Senate Bill 25 will be favorably reported to the floor of the House. Seeing as though there is no further business, the Appropriations Human Services Committee shall stand at recess to the call of the chair.